Hello, my name is Samiksha Jadhav and I work as a Senior Associate at RiskPro India. In today's video, we shall discuss about the powers of the central government under the Digital Personal Data Protection Act. Now, before we begin with the video, I would like to mention that this video is based on individual interpretation of the Act. Moving on, a plain reading of the Act provides us an insight into the DPDPA Act and the wide power it provides to the central government. The central government is responsible for shaping and implementation of the Act. Now we shall discuss about what kinds of powers does the central government have under the Act. 1. The most important of all is the power of rule making. The central government is responsible for drafting of the DPDP rules. Even though the Act is in force, a lot of its provisions are open-ended, and a clarification upon this would be given by the DPDP rules. Second, the central government's power to grant exemption. The central government can, by notification, grant any data fiduciary, class of data fiduciaries, including startups, exemptions under the Act. Now, this shall depend upon the volume and the nature of the data they are processing. Third, the central government by notification has a power to exempt any state or central government agency from processing of data, provided this processing is done to uphold India's sovereignty, integrity, or to maintain state security, or for maintaining public order, or preventing any crimes, or maintaining friendly relations with foreign countries. Next, central government shall be responsible for establishment of data protection board. In this case, the central government would be responsible for appointment of members, for providing terms of employment, the location of the data protection board, etc. Next, the central government by notification make any data fiduciary as the significant data fiduciary. In this case, the data fiduciary who has been made as the significant data fiduciary shall also be liable for the obligations under section 10 of the Act. Next, if the central government believes that a certain data processor is responsibly and safely processing children's data, it can, by notification, exempt that organization for some of the obligations relating to children's data processing. Next, the central government has a power to restrict transfer of data outside the territory of India. 8. The central government has immunity against any action it takes in good faith. This means no legal proceedings shall be made against the central government if they take an action in good faith. 9. The central government has the right to call upon the board or the data fiduciary or its intermediaries regarding any information, and they need to provide that information to the central government. 10. If the data fiduciary has been fined a lot many times and more than 2 times, and the regulatory body, that is the data protection board, is of the opinion that the access of this data fiduciary shall be restricted, the central government can step in and restrict the access of this data fiduciary. Now, the powers of the central government under the Act are wide in scope, and thus their role becomes very critical regarding the oversight and implementation of the DPDPA Act. Thank you.